Hello, this is John Milburn for Central Queensland University. Today I'm going to speak to you about the Environment Protection and Biodiversity Conservation Act of 1999, EBPC, which is of course Commonwealth legislation. It's very important environmental law legislation, and it provides a mechanism for the Australian Government to join with states and territories to provide a national scheme for environment and heritage protection. It also deals, of course, with biodiversity conservation, and it provides methods for controlling the movement of plants and animals and dealing with other issues such as threatened species. And it provides an opportunity for the promotion of ecologically sustainable development through the proper use of resources. The Act also provides for the recognition and use of Indigenous peoples' knowledge of the biodiversity. So if we look at the Act itself, and I'd recommend that you call the Act up now and follow this as I'm speaking, have a look at Section 3, which deals with the object of the Act. And you'll see that the first point made in the Act is that it deals with environmental issues that are of national environmental significance. That's something which will be important in the context of controlled actions that we'll discuss soon. Apart from that, the Act is designed to promote ecologically sustainable development, promote conservation of biodiversity, deal with conservation of heritage, make cooperative approaches, and importantly, recognise the role of Indigenous people and implement cooperatively Australia's obligations internationally under treaties. A common theme in the legislation is the concept of ecologically sustainable development. In that regard, look at Section 3A of the Act, which deals with that point. And there are a number of important principles that you need to be aware of when it comes to dealing with ecologically sustainable development. The important thing to consider is that in the context of decision-making under the Act, both long-term and short-term factors must be considered, not just ecological or environmental matters per se, but also economic, social, and equitable considerations. The Act also gives important effect to international principles that have filtered down through treaties and now in legislation, such as the precautionary principle. So 3A states that if there are threats of serious or irreversible environmental damage, then lack of full scientific certainty should not be a reason for postponing measures to prevent environmental degradation. The Act also deals with principles such as intergenerational equity, that is, that the present generation should not act in a way as to act to the detriment of future generations, and also deals with biological diversity. So, as I mentioned earlier, the Act importantly deals with matters of national environmental significance. And these include matters that have a significant impact on some things such as the list of 9 things: the World Heritage Properties, Heritage Places, Ramsar Wetlands. And bear in mind that a Ramsar Convention is the Convention on Wetlands of International Importance. And have a look at the Ramsar website in that regard. Threatened species, nuclear actions, Commonwealth marine parks, the Great Barrier Reef, and water resources from coal seam gas development. So what is something that will trigger the effect of the legislation in a practical sense? Well, the Section 523 of the Act defines an action as including a project, a development, an undertaking, an activity or series of activities, or an alteration of any of these. I mentioned earlier the importance of the concept of a controlled action. Have a look at Section 67 of the Act, and that states that an action that a person proposes to take is a controlled action if the taking of the action by the person without approval would be prohibited by the provision. And Section 74 AA states the penal provisions for the breach. So what should someone do if they propose action, and remember that's a project, a development, an undertaking or an activity, and they think it may be something which, if they proceeded without authority, would be prohibited. What should they do? Well, the proponent refers the action to the minister for consideration. That is the federal minister, who must decide whether it's a controlled action or not. A state or territory can also make this referral to the federal minister. And the Act makes it clear that the preferred approach is for the proponent to refer any proposed action at an early stage in the development, so that this preliminary decision can be made by the federal minister. Now, upon receipt of the proposal, Section 74 of the Act provides that the Commonwealth Minister must invite other Commonwealth ministers to provide information, must invite comment from the Australian Heritage Council, the appropriate state or territory minister, and of course the public. I mentioned before that it's for the federal minister to determine whether, amongst other things, there is a significant impact as a result of the action. This question of determining significance is for the subjective, not the objective, but the subjective determination by the minister. Have a look at sections 74B and 75 of the Act, and you'll see that the usual test of objective determination is not included. Now, while significant impact is not defined, do have a look at section 527 cap E of the Act. It has a definition of impact. And also have a look at the Commonwealth's published guidelines on how to determine significant impacts. Those guidelines provide a great deal of value in terms of understanding the way in which the procedures work. I'll now share the screen to show you you'll see there the Commonwealth Government's web page, which is environment.gov.au, and there's a guide to undertaking strategic assessments, and you can download that guide in either PDF or Word form. So the Commonwealth provides you with some assistance in terms of determining what is a significant impact, and the EBPC provides two pathways to achieve approval for actions that are likely to have significant impact on matters of national environmental significance. The first of those, the referral stage that I've been talking about, which is a project-by-project assessment, involves firstly the referral, then an assessment, and then finally an approval. The second, the alternate way, is a strategic assessment process, and both processes have benefits and are appropriate in different circumstances. Now, I mentioned that the federal minister, determines subjectively whether or not a particular action is a controlled action. The minister must make the decision, but must apply the correct test. Have a look at the Nathan Dam case for an example of where the court determined that the minister had not applied the correct test. The background of that case, which is cited at 2004 134 LG-ERA 272, was that the minister had to determine the question as to whether the Nathan Dam construction was a controlled action or not. The minister said no. The Queensland Conservation Council took the matter to court and correctly argued that the minister had adopted the wrong test. In that case, the minister had considered the term impact too narrowly, and the court said that the minister should have considered a wider impact. So the minister considered the impact of the dam itself. The wider issue was the impact of the use of the dam water, which had been made available to irrigators, which then could cause adverse impacts from discharge. So the test for the minister is subjective, it's discretionary, it's wide, but it's not unfettered. out of interest, that dam proposal for the Nathan Dam is currently before the Coordinator General. And what I'll do is attempt to, no, I won't do that. Have a look at the Coordinator General site, Queensland Government, and you'll be able to see the progress of that particular action. So Section 76 of the Act provides that the Minister may require further information, and there are time limits that apply. So be aware of those time limits, and in that regard, have a look at Sections 74B and 74C. So that's the referral process. The second stage I mentioned is the assessment process. And again, we go back to the Intergovernmental Agreement on the Environment. Those documents provide certainty as to the process, the procedures and the functions, particularly in relation to environmental impact assessment processes. It's important to avoid duplication of process, and the way in which that's done is through the use of bilateral agreements between the Commonwealth and the relevant accredited state or territory. Now, a bilateral agreement is an agreement between the state or territory and the Commonwealth that provides for accreditation of the state or territory processes for environmental assessment or approval of actions. So the actions that would otherwise trigger the requirements for assessment and approval under EBPC, that is the controlled actions, do not need assessment and approval if they are conducted in accordance with the bilateral agreement, where the accredited state process is undertaken. And that's all part of the IGAE. So if the Minister federally determines that a particular matter is a controlled action and not otherwise exempted, then the Minister may choose one assessment approach. Have a look at Section 87 in that regard. Those approaches that can be adopted for assessment are by the accredited assessment process, assessment on referral information, assessment on preliminary documentation, public environment report, environment impact statement or inquiry. So the point to take from this is that the Federal Minister goes through the referral process, then in terms of the assessment process, must choose the appropriate assessment process, but bearing in mind the arrangements under the bilateral agreement approach. Right, the third step is the approvals process. Again, as you might expect, there are time limits that apply in relation to these things. Have a look at sections 130, subsection 3 and subsection 4, where there are time limits as to when the Minister must decide whether or not to approve the taking of the controlled action. And the Minister must consider matters relevant to any environmental value that the Minister determines needs protection. Have a look at section 130, subsection 1. What that means is that the Minister must consider the consequences of action, but there is no obligation to consider the consequences of inaction. And of course, as you might expect, the Minister may attach conditions to any approval. Have a look at section 134. Thank you for listening.